People who are inherently hot-tempered and abusive and violent don't go for their whole lives without getting convicted of crimes related to those personality flaws. And yet there's Mr. Monahan with no criminal convictions. So rumors and speculation on one hand, clean criminal record on the other, that should put to rest those rumors and speculation. And the idea that he got in an argument at DMV, join the crowd. Lines in back of me. You know, if that becomes a bail criteria, everybody that gets arrested in New York will go to jail. No, this is not going to help my case. It's not going to help my client's case, and I don't think it's a fair use of the bail statute.
You said earlier that not all tragedies have villains.
That's right.
Is your client a villain?
I don't believe he is. I believe there was a series of mistakes in this case made on the parts of more than one person, and I don't believe there's any malefic intent on my client's part. I think you need malefic intent or evil intent to be a villain. I take cases to represent the rule of law. I take cases to protect the integrity of our judicial system and our Constitution. Defense attorneys don't need to believe that their clients are innocent or believe that their clients are guilty. Our job is to serve the function of the law. Nevertheless, I evaluate cases on a case-by-case basis, and I look at Mr. Monahan and I look at the facts as I know them now, in the infancy of the investigation, and I don't perceive malefic intent.
What was the intent then?
That's going to be the trialable issue. That's going to be the theory of the defense at trial, and it's way too soon to comment on that.
Is he remorseful in any way about what happened?
Yeah. My experience in dealing with anybody who's in a violent situation when someone gets hurt, you have to be careful about defining remorse, because on one hand, you can be remorseful for what you did, or you can be remorseful that something bad happened. And I think Mr. Monahan is on the I'm remorseful, something bad happened spectrum. You know, I didn't want to really talk to the press much about this case until the sheriff started talking about things he didn't know. And this idea that Sheriff Murphy comes out and blasts my client in the media saying that he's not remorseful, how the hell does he know? He never talked to my client. And in fact, none of his investigators talked to my client because my client invoked his right to counsel. So none of them know. So, you know, he's spreading this stuff around the national media that my client's some kind in inference, some kind of cold-hearted killer with no remorse. And all he's doing is peeing in the jury pool. It's not acceptable. And I've not been shy about proclaiming that.
Some of the media have reported that your client is cantankerous, though, and has had property disputes in the past. Do you have any knowledge of that, Kurt?
I don't. I've represented a lot of people that have property disputes. I had a property dispute once. I mean, that's the nature of owning property and having neighbors. That's, who is it? Robert Frost said, good walls make good neighbors. But he doesn't have a record. He doesn't have a penal law record. And when you're 65 years old and you don't have a penal law record, that says a lot. Even any 20-year-old can say, I don't have a penal law record, but hey, you're just getting started. He's 65, he has no penal law record. And instead of focusing on that, they want to focus on an argument at DMV.
And a DWI conviction
43 years ago. God forbid anybody hold me responsible for what I did when I was 22. I mean, you come in here, your brain isn't fully formed until you're 25. So, I mean, come on, that's not a bail. But to Judge McLean's credit, he said that's not a factor he's considering.
But as we stand here today, you're certain that your client is no bail risk or no flight risk, which is what bail is intended to prevent.
The word certain does not belong in the legal profession. It just doesn't. There are no certainties in life except, what, death and taxes, and there are no certainties in the legal profession. My argument is an objective view of my client's life, including his lack of record and his ties to the community and the other bail statutes, would cause me, as a judge, to look at him and say, he's just not a flight risk. You know, somebody who's just moved here from Alaska and has bounced around their whole life with no ties, no home, no job, yeah, they're flight risks. You can't get more embedded in the community than my client is. 33 years, own business, owns his own home. I don't. Those are factors that all say no flight risk.
Comparisons have been made to what happened in Missouri with the 84-year-old gentleman and Mr. Monahan here and Ms. Gillis. Was your can you describe his state of mind that night? Was he startled by all this?
I was on the phone with him starting 11:40 at night, and this is the other thing I want to debunk. Somebody in the media took the sheriff's words. I don't think the sheriff actually said it. There was some kind of standoff, or the sheriff did say uncooperative. The first sergeant that was on the scene, I talked to on speakerphone. He was on my client's porch, and he would not tell me what they wanted to talk to my client about, what had happened, or what, if anything, they were going to arrest Mr. Monahan with. And then he asked me, well, why don't you let me talk to your client? I said, because I'm working completely in the dark. You won't tell me anything. I said, who's your superior? Because before I can advise my client, I at least have to know what's going on. So I ended up talking to Under Sheriff Winchell about 20 minutes to 30 minutes later, and State Police Investigator Hank Abiel. And the three of us sorted it out. That was the first time either I or my client heard that there was a fatality. And my priority then shifted to, my goal tonight is to get my client out of that house in a safe manner, to allay the fears of the law enforcement, who by that time had rolled an armored vehicle into his driveway and arguably probably had a SWAT team. And I didn't want anybody getting shot. And so, with the promise of the police that they wouldn't seize any evidence that they didn't have a warrant for, and that they wouldn't interrogate my client, and they kept their promises, they were both honorable about that. I arranged for my client and his wife to exit the house safely. That's not a standoff. A standoff is when someone comes to your house with a warrant and says, I have a warrant for your arrest, get out of here, and in a Jimmy Cagney fashion, you slam the door and say, you'll never get me alive, coppers. Yeah. That's a standoff. This wasn't a standoff. And the idea that he wouldn't consent to a search, wouldn't consent to waive his right to counsel, and wouldn't give an incriminating statement, the sheriff has characterized that as being uncooperative. Well, okay, maybe there's a job opening in North Korea for you, Sheriff Murphy, because this is the United States of America, and the Fourth and Fifth and Sixth Amendment are the most American things we can stand up for. And someone who invokes their rights, then to be lambasted in the national media as being uncooperative as an indicator of guilt, again, he's peeing in the jury well. And it's not appropriate, and that's not American jurisprudence as I understand it.
Finally, what was his state of mind? You did talk to him.
Again, I don't want to get too much into that attorney-client privilege, and I make certain comments only to rebut what I consider to be the false narrative that Sheriff Murphy has put out there. I don't want to go deeper into it than that.
Was he threatened? Did he feel threatened?
I don't want to go deeper into it.
Okay. And you're a gun owner yourself.
I've been a gun owner. I've been a firearms instructor. I taught for about 7 years at the Caterhorse Fish and Gun Club, Article 35, self-defense in the law, in the concealed carry course. If you wanted to get a concealed carry permit, you would have to take this course and hear the lecture from the attorney. My teacher is Mausert. He was a cop in New Hampshire for 35 years, foremost expert in the country on the use of force. It's my favorite area of the law, so I'm a gun owner and I'm very well versed in that area.
Well, many people have made this a gun case. Do you see that? Is that the right conclusion?
I don't think it is the right conclusion. Letting people who have no experience or knowledge of guns write laws about guns is like letting people who have never driven a car write laws about cars. If I had my way, just as a personal digression, no one would own a gun, any kind of gun, shotgun, rifle, or pistol, without a minimum of a 40-hour course, at least half of which was legal and with a written test at the end, and half of which was arranged with a police qualification course. The idea that anybody can walk into a sporting goods store and walk out with a shotgun or a rifle, look, I believe in the Second Amendment, I believe in gun ownership for self-defense, but if you're going to drive a car, you got to be qualified on the rules and on the mechanical operation. And if you're going to own a gun, the same should be true, whether it's an AR-15, a 12-gauge shotgun, or a revolver.
Excellent.
So,
anything you want to add? I appreciate your time.